5 o'clock on the dot. We should get started. Hello, everyone. Thank you for tuning in. Um, Welcome, first and foremost. This week's topic is mediation and collaborative family law explained. So there's the four of us today. We're going to do a deep dive into all things mediation and collaborative practice. We do have a Q&A feature for our viewers to submit any comments or questions you may have throughout the show. We will do our best to get to them. And first and foremost, the purpose of the series is to discuss general information on separation, divorce, and all other family law matters. And any information that we do provide today and any week for that matter should not be construed as legal advice. And if you do have any questions regarding your specific matter, please feel free to call our office or a lawyer in your area to book a consultation to receive tailored personal advice. So, drum roll, introductions. We have Shanza Sohail, and she is a recent law graduate from Osgoode Hall, and she is an articling student at the firm, and she has plans to be called to the Bar of Ontario in June 2024, very, very soon, 2 months away. And Shanza is focused on launching her legal career in family law and is dedicated to providing empathetic and proficient legal support for those navigating family-related complexities. Her valuable experience stems from active participation in legal clinics, mooting competitions, and her prior work as a legal assistant. As she embarks on her legal journey, Shanza is poised to contribute to the firm's commitment to excellence in family law, leveraging her diverse background and unwavering dedication. Russell is the founder and senior partner at Russell Alexander Family Lawyers, and with over 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them cope with the difficulties of separation and divorce. Russell has written 4 books and is fully trained, as with the rest of us, in collaborative practice, and he is a collaborative practice lawyer. And he speaks at conferences all over North America on collaborative practice, marketing, technology, and the law. Steph has been with RIA since 2018, and she was called to the Bar of Ontario in 2022, and she is now an associate lawyer at the firm. She completed her undergraduate degree at Queen's University, and she received her law degree from the University of Liverpool in 2020, where she graduated with first-class honors. She's also trained as a CP lawyer, as I mentioned previously, and she is committed to assisting clients through what is traditionally a difficult time by approaching matters with empathy, integrity, and compassion. Last, but certainly not least, is myself. I am an articling student at the firm, and I am also set to be called to the Bar of Ontario in June 2024. I am a graduate of the Ted Rogers School of Management at Toronto Metropolitan University, which was formerly Ryerson University, and I am a graduate of Queen's University Faculty of Law. And as I enter the next phase of my legal career, I am committed to positively influencing the lives of those facing difficult family situations. And outside of the office, I love playing hockey, watching Will Ferrell comedy movies, and cheering on the struggling Toronto Maple Leafs. Russ, you're muted.
They won last night. Why are you saying they're struggling?
Because it was 5-1 and they let them crawl back into it, and it was 5-4. And if Austin didn't get that empty netter, not making, I don't know, too close for comfort.
I
And
feel
I
like
think
they like their fans to sweat.
Yeah.
They just
Well, Marner wasn't playing last night, right? He's back Wednesday or next week?
he's still not back. So Riley's back tomorrow. Morgan Riley's back. I don't know. I think we're going to be playing Florida in the first round. So we'll see what happens.
All right. Let's not keep our audience waiting on
Exactly.
sad tales of the Maple Leafs.
Exactly. We will definitely jump right into it. So our first sort of topic for today's discussion is understanding mediation, and Shanza is going to explain how it works and its role in resolving family law disputes.
Sure, thanks, Joe. So when you go to mediation, you're essentially resolving your family dispute with the help of a neutral third party. And this neutral third party, the mediator, assists the parties to reach a mutual settlement. In family law, you can go to mediation for any issue: spousal support, child support, property division, parenting time, decision-making, anything related to your separation, you can mediate. Typically, mediation is informal. It's not adversarial, and That's how it's different than going to court. It's also voluntary. Either party can withdraw from the process at any time. All discussions during a mediation session are confidential and without prejudice. That means that they cannot be used against either party in court proceedings unless you opt for open mediation. In that case, the mediator can report about the process and its results to the court. If you're going to mediation and when you sign your contract, you can specify what can and what cannot be disclosed. Generally, the mediator is there to assist and guide the parties to come to a settlement. They cannot make any rulings or decisions. It's a voluntary process. They also don't provide either party with any legal advice. So it's good to seek legal advice if you are going to mediation. Mediators can be social workers, they can be lawyers or other professionals. And when you're going to mediation, the purpose is to try to reach an agreement. And if you do reach an agreement, you want to enter into a separation agreement or something similar, it will need to be written out and it has to be signed by both parties, which can then become binding. All in all, I think it's important to know that for mediation to work, you need to be willing to try to work out a solution with the other person and just be able to talk about your needs and listen to the other person's concerns and being able to work together to be able to negotiate and come to a settlement. That's my little overview.
Well, the only thing, there's recent changes to the Divorce Act. When I say recent, last 2 years, but it reflects some language they had in the previous act, I think it was Section 9, where professionals and clients have a duty to consider resolving the matters outside of the court system and through, I think the language is alternate family law resolution processes, maybe not quite that complicated. But mediation is a great first step because I see lots of people run off the court. Judge will ask, have you tried to resolve this outside? And they just issued the court application. And so outside the court system, so the judges send them on their way. So you gotta go see a mediation, do some negotiation before you're gonna get the input of a judicial official. So I think it's a great first step to consider.
Yeah, and Russ, I do believe, have you had a file where there's been court-ordered mediation?
Well, essentially the case management judge is saying, I'm not going to hear you until you go through this process. So it was an order, and although not formally typed up, but we'd gone back and said, we still haven't tried mediation yet. The judge would still not hear us. They'd give us a new date. So effectively it was court order. How about you, Steph? Have you seen that?
I haven't seen it yet, but I have sought it. So just a file that I have right now. We're in the process of seeking guidance from the court and working to get it out of the court. So,
Well, if they're married, they need to comply with the provisions of the Divorce Act, right? So something to consider.
For sure. And there's just so many benefits of mediation. Definitely going to touch on the 3 biggest ones that I see. The first being cost effectiveness. We have clients coming in here saying, how much is this going to cost? And then we always give them the classic lawyer answer, it depends, because it truly does depend. It's very fact driven, but what we do tell our clients or potential clients when they come in for intake meetings is that all in all, mediation typically costs less than litigation, as it involves fewer legal fees and court expenses. What's really great about mediation is that both parties can actually share the cost of a mediator, and that allows it to make it more affordable for everyone involved. And there's also some mediation services that are free of charge. And there's also mediation services that are also priced based on the incomes of parties. So it sort of acts as a sliding scale based on the parties' incomes. And truly, by resolving issues efficiently and effectively, mediation reduces the need for prolonged legal battles, which all in all saves significant financial resources. The next big sort of benefit of mediation is speed. Mediation offers a faster resolution compared to traditional court proceedings, which, as many of you may not know, it can drag on for years. By the time you first issue, by the time your application first gets issued, until you get to a trial, it can be 2 to even 4 years, depending on the nature of your specific matter. So mediation really does offer a faster resolution. As well, parties also have more control over the pace of the process, and that allows them to address issues in a more timely manner. And it also avoids delays that are associated with the court schedules and backlog, which ultimately leads to quicker agreements and full closure. With COVID, the amount of cases that had to been put on hold as a result, and the current backlog, we're still seeing that now, a year and a half after sort of the restrictions have been lifted. I can speak for myself. I know we had a file that wasn't able to get a case conference, so the first appearance in front of a judge for 6 to 8 months after the application was issued. So there truly is a big backlog. So this benefit of mediation sort of allows you to confront your issues a lot quicker. And a third benefit with mediation is sort of dealing with the emotional well-being of both parties involved, as well as even the children, if there are any. Mediation truly does provide a less adversarial environment, and that reduces conflict and hostility between the two parties as well as the children, and it does help maintain better relationships between family members, and that's also particularly crucial if there are cases involving children. And what's really great about mediation is that it allows parties to express their concerns and feelings in a truly supportive and confidential setting. And this allows everyone sort of to have less feelings of stress, less emotional strain, sort of takes the burden off your shoulders, so to speak. And it really allows you to feel as though you're being heard. And sort of above all, it encourages cooperation and collaboration. And what that does is it fosters a sense of empowerment, a sense of ownership over the resolution process. So you're really taking control, and you're allowing to sort of guide it in a way that best suits your specific needs, which is really, really helpful in a lot of cases.
Yeah, those are great tips. Litigation, not mediation, going to court is tough, right? And a lot of clients, the analogy they tell me is like a dark cloud that hangs over their head. They can't sleep at night. They're stressed out. I've got a court date 4 or 5 months down the road. Some third party is going to impose a decision they might not like. They might not see their children. They might lose their property, their home. They might be required to pay support, or the support they receive might not be what they expect. So this emotional toll you're talking about, Joseph, is real, right? And mediation, many clients will say, is less stressful. You're not in a public courtroom. You're in a private mediation center, sometimes in your lawyer's boardroom. You can control the schedule. You don't have to wait several months to get a mediation date. You negotiate an outcome you can find acceptable, as opposed to having an outcome imposed on you and your spouse and your children by a judge who may never meet your children. Not likely. The other thing I would add, and I think this often gets overlooked, is this idea of privacy, right? You file a sworn financial statement with the court, that becomes a public document. Everybody can see your business. Or these affidavits we see are terrible, right? People say things about their spouse they would never say if they weren't going through a divorce. Oh, you left little Johnny in the car when you went into the ATM that day. It's like things get blown out of proportion and feelings get hurt very easily. Mediation is private. You're in a closed setting. If you settle the document, that may become a public court order later. Not likely. You can do minutes of settlement or a separation agreement. So those are some of the very nuanced advantages of mediation that often get overlooked.
For sure. And Russ, speaking of the mediation process, when clients come to you, whether that be through the intake process or someone you've already retained, and they ask you, Russ, I'm really interested in mediation. What can they sort of expect, and how should they best prepare for it?
right? I'm going to talk about preparation later on in today's program, but what to expect at mediation. A lot of it will depend on whether or not you're using a lawyer. If you're using a lawyer, he or she is going to do a lot of this groundwork, and I'm going to explain that in a moment. But let's just say, I'm going to use a mediator I found at the courthouse, or that I found maybe not in the phone book, but in Google. Nobody don't even know if they make phone books anymore, and do it on my own, right? So you may see something like an introductory or an opening statement, a chance for you to tell the mediator your story. You're going to want to identify what the problem is, right? What do you need help with from the mediator? It's the parenting issue. Are you dividing contents, pots and pans? Seeing lots of pet disputes recently, especially out in BC. Pets are popular, right? We're talking about parenting plans for pets. Could be a property issue, could be a support issue, could be mobility, where are the children going to go to school? We see this a lot when kids are flipping out of Montessori or daycare and starting school for the first time. What school district are they going to go to, right? And timing is really important. So you want to identify the issues for the mediator. Maybe you've settled some things, right? So you want to tell your mediator, yeah, we've got the home settled. We agree on the value. We don't need help with that. So everything you've settled, get those off the table. You're going to want to start bargaining and generating options, maybe thinking of different outcomes. Your BATNA is something we talk a lot about in law school, your best alternative to negotiated settlement. So maybe think of it, at one point, am I going to walk away from this thing if we're not making any progress, right? When am I going to cut this process loose? You don't want to think, you want to have you want to go in there with an open mind, but you don't want to get buyer's remorse where you come to an agreement just for the purposes of getting to an agreement, but waking up the next morning and realizing this wasn't a very good deal. I didn't understand what I was signing at 8 o'clock last night after a 12-hour mediation session. Those are always, you want to be cautious about that. So you're going to negotiate, and the mediator is going to facilitate your negotiations, and then you're going to reach an agreement. And sometimes it could be a memorandum of understanding, it could be minutes of settlement, it could be a full separation agreement, it could be a consent to order that you're going to file with the court if you're already in the court process. All these names mean different things and different levels of enforceability. So you want to be very mindful of what you call your settlement document. Usually the amount of time dictates the type of document you're going to sign. So if you're done your session, you're out of time, you want to get a structure in terms of what you've agreed to. Maybe that's a memorandum of understanding. If you have more time, you might want to actually draft minutes of settlement. You're going to want to have an expert, a lawyer, provide you with independent legal advice before you sign off on anything. If you've got lots of time, maybe you're going to draft a full separation agreement, and maybe your lawyers are going to be there and explain it to you and execute it right on the spot. So timing, resources will determine what type of document you end up with. So this is sort of, you're on your own, right? Now, let's just say your lawyer is going to step in and you can go to mediation with a lawyer. Oftentimes, lawyers are going to do a lot of the preparation before you get to meet your mediator. You're going to agree on what mediator you're going to use, what location you're going to use. Usually the lawyers will file briefs with the mediator, identifying the issues, identifying the case law, identifying outcomes that they want to seek. Usually written statements are provided in advance. This could potentially lead to arbitration if there's a disagreement, but that's a subject for that we're going to get to in another night. Tonight we're talking about mediation, which is different than arbitration. And then I'll just give you an example of sometimes some mediators. So if you have an experienced mediator, perhaps a lawyer or a retired judge, and let's just say hypothetically your dispute is a data separation, that mediator, lawyer, or judge may say, okay, I want the lawyers to produce the outcomes based on these 2 dates of what the equalization or the sharing is going to look like. So the separation date will determine the value of assets, which is going to determine how you share property. So at that point, the mediator's job's easy. They simply make a determination or a recommendation as to what the date is. You already know the outcome because the lawyers have prepared that in advance. They know what the calculations are based on different dates. So that's a more fulsome mediation where a lot of the groundwork's done by the lawyers, the financial work, the parenting plans, and the mediators are helping with very salient or specific issues. And depending on how the mediator or you negotiate that issue, you already have a good idea what the outcome is going to look like. So in terms of process, oftentimes it's very structured. Sometimes it could be just open-ended, right? You sit down with the mediator and you get at it, right? There's no agenda and the mediator works through the issues one by one. Other times it's much more structured and much more formal in the sense that we've got complicated legal issues dealing with $1 million of assets, and we want to make sure the mediator gets it right and provide them with lots of information in advance. So it's just a taste of what you're looking at, but certainly don't let the process discourage you, because whether you're in mediation or court, you're still going to have to produce the same information. The difference is you're not having a judge adjudicate the matter and impose something on you. You're negotiating an outcome in mediation that you find acceptable, that works for everybody.
Yeah, and oftentimes I think people seem I don't want to use the word intimidated, but maybe it's just because they don't have a full understanding of what mediation actually comprises of. So they just think, oh, I'd rather just go to court, I'd rather just do this. But like, take a step back. Like if you truly understand the practice of mediation, you reach the same goals as court, except you're doing it sort of, as Russ mentioned, on your own terms, and you're doing it where you have more control over the process, more control of your own finances in terms of the cost to go through the process. So it is a really great alternative. We will talk later in the show about where it might not be the best alternative for you to go down that road in that process, but for most matters, it really is. It should be the first step.
Yeah. Got a question about negotiating child support and mediation. You can negotiate. If you're deviating from the guidelines, you want to provide an explanation as to why you're deviating. A judge will not give you your divorce order unless you have a good explanation, and a court may not enforce it. So there's reasons why you can deviate from the guidelines or negotiate a retroactive support claim, but that's sort of beyond the scope of what we're talking about today. But it's a great question. Thank you for sending it in.
Yeah, thank you very much. So Russ just spoke to the mediation process, but oftentimes clients sort of don't understand, the role of mediators themselves. So I'm going to speak to that. I'm sort of going to divide it between responsibilities and sort of their purpose for facilitating agreements. So beginning first with responsibilities, the role of a mediator is to truly facilitate communication and negotiation between the parties with the goal of reaching mutually acceptable agreements. And in doing so, they remain neutral and impartial throughout the mediation process, which means that they don't choose a side. They remain in the middle, and that allows to ensure fairness and balance within the process. They also help parties identify their underlying issues and interests and needs, and that allows them to guide them towards creative solutions, because oftentimes parties come to the table and they sort of portray what they want, and they don't really understand their needs and their interests. And I think that's sometimes where we see people butting heads. And more often than not, once the mediator allows people to sort of project what their underlying interests are, that's what allows them to come to an agreement and solution. Mediators also manage emotions and conflicts effectively by promoting constructive dialogue and problem-solving skills. And as Russ mentioned earlier, sometimes they will actually help draft the agreement. Them not drafting themselves, but what they'll do is they will construct a memorandum of understanding. So all the dialogue that's gone on in that meeting, they will sort of comprise that into a document for both parties to review. It should be factually correct. And then based on that, the parties themselves, with the help of the mediator, if lawyers are involved, if counsel's involved on both sides, they'll take that memorandum of understanding, and as Russ said, they can convert that either into a minutes of settlement or a separation agreement, and the separation agreement can be filed with the courts just in terms of greater enforceability. And with respects to facilitating agreements, mediators encourage open and respectful communication between the parties, and that allows the creation of a safe and confidential environment for discussions to occur. And they use active listening and empathy to understand each party's perspective and interest, which is also really key in coming to a resolution. And they assist the parties in generating options that they might have not have thought about previously, and as well as exploring alternatives to find mutually beneficial solutions that, like I said, other parties may not have thought about initially before coming to the table. And they provide guidance, and sometimes what people don't like to hear are those reality checks to ensure that agreements are realistic and sustainable in the long term. And all in all, they help parties overcome impasse. Basically, that means impasse is any obstacles or barriers that may occur in reaching a consensus and an agreement. And again, they facilitate sometimes the drafting and finalization of agreements. That's more so just to ensure that everything that was agreed upon is hopefully put pen to paper.
Can I tell a story?
It's always story time. Let's hear it.
So when I mediate, I always like to use the senior counsel, usually more senior than me. They're getting hard to find, unfortunately, but we used to go to Phil Epstein all the time in Toronto. Great guy, renowned lawyer and educator. So what I liked about using a lawyer with some experience is they would also give you some guidance during the mediation, right? And say, okay, well, here's what I think you should settle for. And it's got some credibility, right? Because they've done this for 30 years or 25 years. And in terms of being a professional, when I'm thinking about my professional liability, well, if I've settled my client's case in accordance with Phil Epstein's recommendation, I'm pretty comfortable that we're out of the woods in terms of any kind of complaint later on in terms of what the settlement should look like. So, and then we've had some very high-end case with millions of dollars in support claims, and when you get over $350,000 a calculation, there's a lot of discretion in terms of what the range of support should look like. So that, you know, it's a big dartboard, right, that you're trying to get right. And when you have an experienced mediator who's dealt with these cases before, giving you a recommendation and a range, as counsel and as my client who's I'm going to be advising, usually that gives us a comfort level, right? You're not sure if this is the actual result a court would come up with. The court may come up with a different result, but you know it's in the ballpark, right? You know this is within the range. And so that enables me to, you know, put my opinion and my advice into some context in terms of whether the client wants to accept this proposed resolution and what the choices would be if they don't. So that's just my little story on mediators and how valuable they can be.
Thank you. Thank you. Yeah.
Story's over.
No, for sure. I think that there's some great mediators. I know a question came in speaking to sort of qualifications and if that matters with different mediators. We're definitely going to discuss that later on. But now we are going to switch gears. We've spoken about mediation, but now we're going to move what's called to collaborative family law. As I mentioned in our introductions, all four of us on your screen are collaboratively trained. But Steph, what is collaborative law?
Yeah, so collaborative law or collaborative process it's another form of alternative dispute resolution. So it's another way to settle your family law matter without having to run to court. In fact, collaborative practice strongly encourages both parties to commit to the process. And to do that, many collaborative files will have both parties sign what's called a participation agreement. So what that essentially does is both spouses sign this agreement that says, we're fully committed, we're going to be transparent, and neither one of us is going to threaten court against the other party. You know, if you don't agree with this, I'm just going to take you to court. So one of the incentives to be committed to this process is should, for whatever reason, the collaborative process break down, neither one of you can keep your lawyer. You would have to, you know, start from scratch, retain a new lawyer if you wanted to proceed to court. And the idea behind this is because everything similar to mediation, everything that's discussed in the collaborative process is without prejudice. It's to emphasize free idea sharing, and you know, you're not going to hold something against the other party for raising that as a possible resolution. So this transformative process is really focused on what each party's goals are and what their interests are. So Russ spoke a little bit about it last week, you know, really focusing on what is the desired outcome, or what are the key components that are non-negotiable or that you want to see for your family, for your child, children, whomever. So in order to help work towards an agreement and work towards a resolution, what the collaborative process offers is a chance to engage the assistance of other neutral professionals. So this team approach can sometimes involve a family neutral. It can sometimes involve a financial neutral. And these professionals are called neutrals because they're unbiased third parties. They are retained by both spouses, like they're mutually retained. And the idea of adding these professionals to the team is the right person for the right job is assigned. So rather than both spouses having their own lawyers, you know, paying their own lawyers to do their financial statement and gather all the disclosure and prepare that net family property statement, that statement that sort of highlights all of your assets, all of your debts, instead of paying two lawyers to do the same thing on both sides, you hire a jointly retained financial professional who often is a lower hourly rate, and they work with both parties offline to establish the financial statements, the net family property statements, all the financial issues. And the same is said with a family neutral. Usually a family neutral could be somebody with you know, a child psychology background or a social work background, or they understand the complexities of the emotions that are so embedded in a separation, and that also provide a great, you know, great insight on any children, or how the separation could affect children, or how do you tell your children that you're separating. So they're a great resource to start working together with both parties to establish a parenting plan. So once the family professional, the financial professional, a lot of the groundwork is done, that's when often we see what's called a full team meeting. Everybody meets together, whether it's in person, or there's a lot that are happening on Zoom nowadays. And we talk settlement. You know, what are your goalposts? What are my goalposts? And how can we negotiate so that both parties can walk away with a final binding agreement that they can live with, and that is really a collaboration of what their goals are and what their interests are. So uh, the end goal for many collaborative files is a fully combined and encompass separation agreement. And it's to provide you with, you know, a roadmap on how you're going to move forward. A lot of these family neutrals, financial neutrals are great people to speak to about what happens next. How do I start to budget now that we're two independent households? What happens if you know, something changes down the line? Instead of both parties running to their lawyers, they can use the alternative dispute or dispute resolution clause to go back to that neutral in order to iron out any hiccups or changes that might come along down in the future. So that's sort of broad strokes of what the collaborative process can look like. And most jurisdictions will have a collaborative practice group. So if you are looking for a lawyer who is collaboratively trained, I strongly recommend going to those websites, trying to find a lawyer in your area, or, you know, if a lawyer is, if you're doing things virtually, maybe even a lawyer outside your jurisdiction would be able to assist. But yeah, we'll provide maybe some links of those practice groups in the show notes.
Collaborative practice like supercharged mediation. It's the best of the best, right? You get the best professionals, best neutrals, focus on goals and interests. You're mediating, you're negotiating, you're working collaboratively. It's really like supercharged mediation, but with specific rules and a practice agreement that you follow on a roadmap. And we talk, like Steph said, we talked lots about collaborative practice in other programs on our podcast, YouTube videos. We'll share that in our action notes.
For sure, for sure. So Steph gave a great rundown, basically giving us all an understanding of this cooperative approach to divorce. But Shanza, we haven't heard from you in a while. How do lawyers in the traditional, you know, adjudicative process, how do they differ from collaborative lawyers?
Yeah, so Steph really just hit the nail on the head, like explaining how the process works. And like she said, like when you are in collaborative, the whole idea behind the process is the commitment to work cooperatively with respect to be able to reach a resolution without having to go to court, without fighting each other, without being at each other's necks, right? And this affects the role of lawyers because now their focus is not on being adversarial, but rather to encourage the parties to work together, to come up with solutions together, so mutual agreement can be reached. The idea is to, like I said, work together as opposed to working against one another. And this is true for everyone, not just for the clients, but also for the lawyers. The guiding principle of collaborative practice is respect. The lawyers and the professionals, their job is to create an atmosphere of understanding, of cooperation. There will be, like during the meetings, there will be open discussions. There won't be an exchange of aggressive correspondence between lawyers. And both parties will kind of dig deeper into the, as Steph mentioned, the goals and interests of each party, not just what their positions are. And knowing what these underlying goals are, it'll help the lawyers understand where everyone is coming from, and it will allow the lawyers and the whole team and the professionals to together to come up with creative solutions to the issues and help both parties reach a compromise. And we've hit on this, like the collaborative process is very client driven. The parties have the rights to make all the final decisions. They have all the say. There is no third party guiding the process, unlike mediation. And so the lawyer has the role of a guide, a support. They provide legal advice, and they ensure that they're there to ensure that the process stays on track, it stays positive, and it stays productive. And I think another thing I would hit on is being in collaborative doesn't mean that there won't be disagreements and difficult conversations and negative emotions. That's part of the process. But the lawyers and the professionals, they're there to diffuse these negative emotions and, Joe, you said it, like address any impasse and get past these barriers to come up with a possible settlement for the parties involved.
Yeah, a couple things. Impasse is normal, right? You gotta normalize it. We do a 3-hour presentation on how to get through impasse. I love your comment, Shanza, aggressive correspondence. Like, yeah, did we take a course in this in law school? Like some lawyers like, holy, where the hell did this letter come? I have to put the letter down for 24 hours, right? And like let it marinate for a while before I respond to it, because it's like a black hole with some of these nastyograms that lawyers seem particularly well equipped to draft. But we did have a question come in. I want to talk about it real quick. Thank you, everybody, for sending your questions in. This is asking about being part of Adrio or Fridrio in neutrality and experience. Great question. Adrio, Fidrio, great organizations. Pre-pandemic, I used to speak at Fidrio all the time. Great group of people down there. Sure, become a member. You're going to get training. You're going to network. You're going to develop your business as a mediator. It's always a great idea to connect with other professionals and learn. And it's certainly something I would encourage.
And it's also important to note that all mediators that you are going in front of, they should be accredited. I know there's the Ontario Association for Family Mediation. A lot of mediators have that accreditation. It's OAFM. So that's also really important. And yeah, you always want to make sure that they're accredited. We are going to speak to the different types sort of mediators that you can come across a little bit later. But now we are going to sort of shift gears away from collaborative family law, and we're going to go back to mediation. We've spoken a little about this earlier on in the show about taking those mediation decisions and sort of turning them into enforceable orders. Steph, how do we create binding agreements for mediation? Please enlighten us. Tell us.
Yeah,
Give us your wisdom. Give us your wisdom. Tell us.
Well, again, it goes back to just what type of agreement or what type of documentation you get. Personally, I would always recommend a fulsome separation agreement, a fulsome mediation agreement, because you can take that agreement and turn it into a court order if necessary. It is also important to note that signed separation agreement, so signed by all parties, witnessed, dated, it is a domestic contract. It's a legally binding agreement. It's always best to have independent legal advice. It's always best to have full and transparent disclosure. There are provisions of the Family Law Act that deal with setting aside a domestic contract. So you want to be mindful that all of your T's are crossed, all of your I's are dotted. But yes, if you enter into an agreement, whether it's through mediation or through the collaborative process, you can file those domestic contracts with the court. You could do so through a Form 26B, I believe, which is an affidavit for filing a domestic contract. And sometimes your agreement may detail what provisions of your agreement are to be turned into a court order. Sometimes your agreement may detail next steps for obtaining a divorce if you were married. But the benefit of filing your domestic contract, your separation agreement in the court, is it does assist with enforceability. So say you have support clauses in your separation agreement, and the payor, so the person who's to pay support, isn't following through, they are behind, you've exhausted your options for alternative dispute resolution. At least if your separation agreement is filed within the court, you can go to the court and ask for assistance to enforce that agreement. Usually we encourage people to follow their agreement. Well, we always encourage people to follow their agreement. You know, it's hard to say run right to court to try to enforce it. There are steps that you can take prior to going to court, sending an email, sending a letter from a lawyer, notifying them or providing notice that they are in breach of the agreement, they're not complying. But you do have at least some aids if your matter is filed in court, or your agreement, sorry, is filed in court.
It sort of makes it more concrete, right? Because you have the agreement, and when it's sort of filed with the court, it's there, it's an order, it's an extra safety net that people often don't realize is available to them.
100%.
But as we know, well, at least the four of us know, our viewers might not necessarily know. We did speak about this earlier, or I did sort of highlight it earlier, but mediation is maybe not always best suited for each and every case. It's very fact dependent, and there's times when it's not necessarily the best course of action. Shanza, when are those cases?
Yeah, like you said, Joe, mediation is not for everyone. There are cases where we wouldn't recommend going to mediation. I think it's best suited for couples who can maintain some sort of respectful communication and share a desire, perhaps, to reach a resolution. It'll work for parties who can interact with each other. If there's children and the parties are trying to co-parent, and if they can co-parent effectively, I think mediation would be great in those cases as well. I think people who are seeking to move on and end things quickly without conflict, these are all signs that mediation is for you. But if there is history, I would say, of abuse or some other forms of power imbalances between the parties, mediation may not be the best course of action for those couples. Domestic violence, trauma, control issues, all of these can inhibit the spirit behind finding a resolution and the ability of the parties to be able to negotiate and talk freely. It's important for the parties to feel safe and feel heard. And if you're not getting that, then it's hard to reach a resolution. If you have been a victim of a verbal or emotional or physical abuse, or if you have trouble saying no to your partner, I think it's best to maybe bring it up with your lawyer. If you are in mediation, bring it up with the mediator, so the professionals they can respond appropriately to protect you, protect your rights, and make sure that mediation is still the right course for you. I think mediation may also fail if the parties have strongly opposing views and they just refuse to compromise. If one party wants their day in court, they're insisting that they need to go to court and take a very, very rigid stance, then negotiations break down, mediation won't succeed unless the parties are willing to be flexible. Successful mediations usually involve both sides making concessions on maybe the less important matters. When someone brings an ultimatum to the table, mediation is probably not going to succeed. And I know earlier, Russ, even you mentioned this, I think even the skills and the training of the mediator also matter, and it can definitely affect the process and how it proceeds. It's a good idea to choose a mediator wisely, depending on the issues that you're going to mediation for. Lawyers can help with that. But yeah, it's case to case. Mediation can be more suitable for some and not for others. If there are, like I said, abuse, power imbalances, coercive control. And even in those cases, you might still want to go to mediation, but it's best to have a plan. The lawyer should know what the history is of your relationship. The mediator should know, and because they are professionals and they have the ability to address these concerns. So yeah, it's very case specific. It's hard to say in black and white, like if it's applicable for you or not, but it's definitely something that everyone should consider. And sometimes it may not be the best, of course, for you.
When we did collaborative practice 20 years ago, we'd always screen out domestic violence red flag these cases and say they weren't suitable for collaborative practice. But now perhaps the collaborative setting is the best setting for that, because the litigation in court can be a form of abuse too, litigation abuse.
Mhm.
And I think we're seeing a lot of that in mediation, Shanza, where we do shuttle mediation so that people are not actually in the room, but the professionals go back and forth and create safety plans for victims of domestic violence. How are they going to get there? How are they going to get home? And develop detailed safety plans if we're going to be entering into that setting, have security if necessary. So there's some safeguards you can put in place. But do you guys want to hear another story? Is it getting too late for story time?
I'm always down.
It's always time for story time.
You gotta be mindful of triggers, right? These people have been together 10, 20, 30 years. And we had a case where the wife collected these Royal Dalton dolls, right? It was a thing, right? And part of the husband's abuse would be he'd get a hammer and threaten to break the dolls during the relationship, right? And so he'd have this tapping motion, symbolizing recreating the abuse that this lady lived through. Now, it may seem like not that big of a deal, but this is psychological abuse that occurred over several years of the marriage, and it had a real effect on the client. But our family professional in the room would pick up on this signal that the husband, this tapping signal, and the client had told the professional about this experience, and she knew this was a trigger. The husband didn't like the way that particular part of mediation would go, and would do this tapping thing and setting a trigger off, and the wife, she'd shut down emotionally and basically couldn't function because she was remembering the trauma that she lived during the course of the marriage. So we'd call a break because of this conduct, right? That ended up progressing the shuttle mediation because it was just too much for that particular client to handle in that setting. But because she was surrounded by trained professionals, we're able to pick up on it. But had you not had the training, or had you not fully briefed with your client, you would not know this is a trigger, and this tapping motion set off this chain of events for this particular client. But it goes back to what you're saying, Shans, about training and making sure it's a safe place and deciding if it's an appropriate case for mediation. Maybe shuttle mediation will work, or maybe the trauma is just so bad that it's not an appropriate setting. But really great discussion.
Yeah, and that actually ties in nicely. We did get a question about, should family mediators, or I would even go so far to say as, family professionals involved in collaborative files, should they be trained in trauma-informed, coercive control, family violence? And I would strongly say yes, for the exact reason that you mentioned. It's about being aware of, the emotional history and the behavior between these parties. Some of these couples that come to us, they've been together for 20 years. That's a lot of history and a lot of nuances and a lot of very specific ways that they could feel, like you said, Russ, triggered and just shut down emotionally. So absolutely.
And that training is available through the Ontario site, OACP, the Ontario group. The international group offers that training, the IACP. I think OACP is offering it 2 times this year. I think they're 3-day programs. One's coming up fairly quickly, I think in June. So look online for that training. Certainly a great tip and great question. Thank you, Steph.
For sure. And that sort of dwindles down to, so we've provided everyone with sort of the process and everything around mediation and collaborative practice. But now it comes down to, how do we go about this? How do we find a mediator? How do we find a collaboratively trained lawyer in Ontario? Many different ways. What I point people first to is through research and referrals. That's always a great starting point. It's really wise for people to seek recommendations from trusted sources such as maybe friends, family members who have been through the process, or even other professionals in the legal field who may have a good reference. People can also research online directories, the Bar Association, so if they're in Ontario, the LSO, the Law Society of Ontario, as well as other professional organizations for certified mediators or collaborative lawyers who do specialize in family law. As I mentioned earlier, there's the Ontario Academy of Mediators and Arbiters. That's one. There's also the Ontario Association of Collaborative Professionals. Those are both two great websites to find collaboratively trained lawyers and as well as accredited mediators. We will post those links to those groups in the show notes. And going back to what Shanza said, it's also really important to consider the mediators or lawyers' experience, qualifications, and areas of expertise that are relevant to your specific needs. I know Russ mentioned he always likes going to a mediator, to a lawyer who's more senior than he is. I know he also did mention that they're sort of running out. But yeah, so oftentimes we see, at least from my perspective, and I think Russ, Steph, and Shanza would agree, when seeking out a mediator, the first thing we like to do is to find a senior lawyer who's worked in family law for a long period of time, a judge who's also sitting on the family law bench. Those are really great starting points. Of course, going to a mediator who has a background in, let's just say, social work is also really good. But at least from my perspective, you guys can agree or disagree. We can have a round table on it. But going to a mediator who has knowledge in family law is always sort of the best course of action, and someone who's practiced the law for a long period of time or who's even adjudicated in the court, such as a judge, would truly have the best knowledge on family law. So they're really able to guide you in the right direction. While they might not be able to provide you legal advice, you know that their level of expertise sort of can guide the process, and someone who really knows the law is key. Aside from research and referrals, there are initial consultations that people can take advantage of. So it's really, really important to schedule initial consultations with potential mediators or even collaborative lawyers to discuss your case and assess their suitability to your case. You can ask about their approach to mediation or collaboration. You can also ask them about their fees and their payment structure, as well as their availability. Those are all really key factors when making your decision. And it's also really important to pay attention to their communication style, their level of professionalism, their level of empathy and understanding towards your concerns. When I do mention levels of empathy, sometimes you might get a lawyer who tells you how it is. It doesn't necessarily mean they're not empathetic to your case, but at least from what I've seen, you want someone to tell you realistically where you stand. You don't want someone to drag you slowly in the mud and then not tell you everything's going to be fine, everything's going to go like this way. And then it happens that it doesn't go your way. So it's really important that you don't necessarily confuse someone's empathy with them sort of telling you how it is. Because I think oftentimes you would rather know up front where you stand. There's also the issues of compatibility, and trust. It's really important to choose a mediator or a lawyer with whom you feel comfortable with and you can trust to represent your interests effectively. You can look for someone who's impartial, which more often than not, all mediators are impartial, non-judgmental, and that are committed to facilitating a fair and respectful process. And also, it's really important to consider the mediators or lawyers' reputation and track record. If you go look through reviews, see how other people rate their services, that's also really, really important. And finally, which we don't really see often, or people don't take advantage of often, is to ask for clear expectations. So that circles back to the, having realistic expectations and having that conversation with your lawyer. Really important to discuss your goals and priorities for mediation or collaboration, as well as any concerns or preferences you may have. It's really important to be open and honest about your case, not hide certain facts, because that's only going to hurt you in the long run. And it's really important that you understand you understand the mediator or the lawyer's role, the process that's involved, and the potential outcomes. Also important to clarify timelines and steps involved that you may have taken previously with your lawyer or the mediator so that they can be up to pace. And as well as we go back to it, any fees or costs associated with their services. So that's pretty much everything in a nutshell.
Wow, that was great. You're exactly right, Joseph. You don't want to be hearing bad news from the judge or the mediator. Your lawyer should tell you where your weak areas are. And it doesn't mean they're not being empathetic or they're not going to be fierce advocates. It just, we're telling you what the likely outcome is going to be and managing your expectations. I agree, government websites, the Government of Ontario, Law Society websites, great resources to have, but fantastic tips. What do you think, Steph, of Joseph's comments?
Yeah, absolutely. And I think even just the mention of compatibility, a solicitor-client relationship is still a relationship, right? You need to feel comfortable being honest, because if you're not honest with your lawyer, how are they going to help you, right? You can't be hiding things. You can't be misleading them, because then they're not able to do their job effectively. So absolutely, I agree with everything that Joseph said.
Yeah. Shanza, any thoughts?
Yeah, and I'll just say that this is a voluntary process, right? So if you're in this process, you're not confident about your lawyer, about the mediator, well, nothing's gonna happen. It's not gonna go anywhere. So the confidence, the trust has to be there. And if at any point you think that it's not the best suit for you, so be it, right? So if you personally don't show up and you don't think it's going to work out for you, then it's hard for the process to move forward. So it's really important that you do find that the best fit for yourself.
I think you want to also be mindful of what you're mediating. And, my experience is great for parenting issues. The minutia of pickup and drop off times, activities, gymnastics, hockey. Mediators are great at that. You don't want to be paying your lawyer several $100s to figure out who's going to take little Johnny to the hockey game Sunday. I don't know why I always use little Johnny, but it just comes to my mind. Pots and pans. Judges hate pots and pans. You don't want to divide the stuff in your kitchen or your used furniture. That's great, again, for mediators. You don't want lawyers arguing over your couch that has a stain on it that you bought from the brick 10 years ago, right? That doesn't make economic sense. People will argue over it and pay lawyers, but it's not very practical. Other issues like significant real property issues that have tax consequences and capital gains and other things associated with. Good initially with a mediator, you're going to want to make sure a lawyer and maybe a tax specialist gives you some advice to make sure they get that correct. Same with big support claims, and pensions. These can get complicated. Again, a great way to start with a mediator, but you want to get that independent legal advice before you sign off on it to make sure that if you make a mistake on the math on a disposition cost, you could be at a few $100,000. Or there could be a survivor's benefit or something that's been overlooked. So be mindful of what you're mediating and the level of advice you're going to want to seek to make sure that you're making a good deal.
Yeah. Perfect. Yeah, that's pretty much all the all encompassing with respects to that. Guys, we didn't really have a lot of questions today. We do have, do we want to take one from the audience? How does
Well, I've
everyone
got one
feel?
more topic we haven't hit. Do you want to hit it or take it off?
Well, I believe you spoke about it a little bit earlier, but
Yeah,
if you
I didn't get into the preparing. I'll just give you some quick takeaways, and then we'll
Sure.
we could do some quick Q&A because I think we're approaching the top of the hour. So preparing yourself, you want to educate yourself, set clear goals. We did touch upon that earlier. You're right, Joseph. Prepare the necessary documentation for either your mediator or your lawyer. Likely the other side too. It's possible they don't have the documents that you have. Develop your strategy. We talked about BATNA, best alternative negotiated settlement. Come up with some options ahead of time in terms of how are we going to deal with specific issues and outcomes that could be acceptable to you. So consider multiple scenarios. Engage the right professionals. Steph spent a lot of time talking about that tonight. Prepare emotionally. Shanza did a great job talking about those issues. Managing expectations. Joseph touched upon that. Practice active listening. Avoid trying to lay blame during mediation. That's not going to be very productive. That's going to lock people into positions. Try to be constructive. Consult with your lawyer before going into mediation, or get some legal advice just so you get an understanding as to what to expect. Know the format, know the schedule, know where you're going physically. Know how long is it going to take me to get there, or is it by Zoom? Run a technology check. Make sure that you've got redundancy built into your Wi-Fi and your internet connection, and maybe a backup laptop or phone if it's being done electronically. Finally, the only other tip I would say, get a good night's sleep. If I'm going into a big mediation out of town, I'll fly or drive into the city the night before, get a hotel room, get to bed early. I don't want to spend the morning on the Don Valley stuck in traffic, showing up at mediation stress day because somebody cut me off on the way down. So get a good night's sleep. Give yourself lots of time to get there. Go for walks. You know, Steph and I were doing this in the office today. She had her dog in. We went for a walk, got some fresh air. Come back refreshed, ready to start the afternoon. Do this during mediation. Just even if you just go outside the building and walk around the block a couple times during a break or the lunch break. Be mindful of what you're eating, right? If you're eating heavy carbs, it's going to put you to sleep. Maybe choose some healthy options during the day when you're in mediation to keep you on your game. So just some basic tips that many people overlook, but could really affect the outcome of your mediation.
So no Big Macs. You don't recommend them.
Well, Dr. Wells, who did some coaching for our team a few years back, sleep performance, high performance coach, he was entering negotiations and he loaded the other room up with donuts and carbs and sugary products. His team had, vegetables and healthy snacks. The other team crashed mid-afternoon. They ran out of gas. They were hitting the wall. They couldn't function as effectively as his team. So there is a lot of science behind it.
No, for sure.
Remember Dr. Wells coming in, Steph, and talking about that?
I do. That must have been what, 4 or 5 years ago?
It was in person, so it probably would have been pre-pandemic. Yeah.
Yeah.
It's funny, everything's pre-pandemic and
I know.
Post-pandemic.
it's so, yeah, really, right?
Like BCE AD. It's like that's like how we
Yeah.
now it's pre-pandemic, post-pandemic. That's how we talk about time.
Yeah.
I know we are a little bit after the hour, but there are a couple questions we can get to. We can do a quick Q&A. I am going to read them off and then you guys can just pick and choose who wants to answer. So we have a question. How is it decided who pays for the mediator? Can this be paid for proportionally if there's a large imbalance in income?
Great question. My experience, most mediators like to see it paid for equally. It just adds to that that view that they're neutral. I don't like getting bogged down with fees. Proportionate, sure. Maybe we can adjust fees at the end. Usually, oftentimes the person with the money or who's going to be making the payment can fund the process. So I've had clients pay $25,000 for the process with an agreement it would be adjusted later. I knew they would be paying out money at the end through an equalization payment and support, so that it's still shared equally, but it's done at the end of it. So that $12,500 would be adjusted against any payment you make. So lots of options there. I see you nodding your head, Steph. Which way do you like to proceed?
I prefer shared 50-50 for the same reason that you just mentioned, Russ, and whether that's an adjustment later on or at the end of the process, if one party is of, more financial means to fund it at the start. But I do think sharing it 50-50 maintains that that balance, because if off slightly, the person who's maybe funding the majority of it feels that that imbalance or feels that weight.
Yeah, and if you're the person making the payment to fund the process, it's still a lot better than going to court, right?
Oh, yeah.
So there's still great value, and you could potentially resolve matters. So I think I would encourage it. Great question, though.
Do we have time for one more?
One more quick one. Sure, why
Sure.
not?
So, someone wants to know whether or not it's sort of worth it to draft up a kitchen table separation agreement or getting one from a website like Law Depot before meeting with the mediator, to have something sort of drafted before meeting the mediator.
I see a look of shock across everybody's faces. What are you thinking, Shanza? Kitchen table agreement? Found this thing on the internet.
Just the other day, this is funny because the other day I asked ChatGTP to draft a little something for me, and it got it wrong. So I was like, "Are you sure?" And they're like, "Oh, my apologies. I missed this really important law." I'm like, "That's okay, fix it." Well, it fixes it. Well, it's still wrong. So the ChatGTP, you're still wrong. And it kept getting it wrong. So it's a no-brainer. Don't do it.
I had somebody give me an agreement with, referring to the laws of Oregon or something, right? Did you live in the US? No. And did your spouse live? No. So what's it? Oh, I found it on the internet. It wasn't even relevant to Canadian legislation. And this is the risk, right? Because if you don't know what to ask, same with the AI. If you ask a bad question, you get a bad answer. Garbage in, garbage out. But
And you don't always know if it's a bad question.
you don't. Well, lawyers have problems with that, right? We think so.
Yeah, I strongly encourage people to stay away from those types of documents for the exact same reason both Shanza and Russ mentioned. If you want to go into mediation prepared, rather than taking a separation agreement or this draft kitchen table agreement from the internet, just think of the issues that you need to resolve. Can you come to an agreement on a parenting schedule? If you have issues or you have, areas that you need help with, highlight those to the mediator. Like Russ said, go in prepared, take as many issues off the table that you do agree to, and then the mediator can help facilitate those areas that you can't come to terms on, that you can't come to an agreement on. But it also sort of ties into our discussion about picking the right mediator. If somebody has a legal background, has experience in family law, and knows the law, if you come with a law office depot separation agreement and it's talking about the laws in the US or in the UK, and your mediator isn't familiar with family law in your jurisdiction, those kind of things can get overlooked. And you do not want to enter into an agreement that is not binding here, that's not enforceable here, because it goes against the legislation. So be very, very cautious with that.
That's such a great tip. Let's go back to Oregon for a minute, right? So this person drops this agreement on my desk. So now we're looking at 2 years of litigation, right? We've got to set this agreement aside, which we know is going to be set aside. We're in court. We've got to redo, the lawyers have to fix everything, right? We got to come up with the correct calculation. So here you think you're saving a couple bucks, but you've now created this problem that you need to litigate for 2 years, and you don't know what the outcome is going to be. I've had people come in with these agreements. I tell them right up front, just agree to set it aside, because that's what the judge is going to do 2 years down the road, and let's do it correctly. You're going to save yourself a pile of money in legal fees, 2 years of litigation, and you can come up with the correct result. But that's tough, right? Because they thought they had a binding agreement, but they didn't realize it wasn't enforceable. Great question, Joseph.
Well, thankful to the our audience members for being so active today. It makes it really great when you guys interact with us. It allows us to really give that information to you and direct the information to what our audience needs. So that's great. Thank you everyone for joining us today.
Fantastic job tonight, Joseph, with the host. Oh, I see.
Yeah, that's why I was a little flustered at the end there because someone wanted to come play.
I see a wild animal there. Shanza, fantastic. Staff, great job tonight as always. And thank our audience for joining us. It's been a great evening.
Thank you, everyone. Have a good evening.
Thank you.
Everyone.
Thank you.